It's a pleasure to have with us Rice County Attorney John Fossum with our monthly visit. Thanks again, John, for coming in.
Well, thanks for having me, Gordy.
Appreciate it. I know you had to kind of boogie to get over here, so we appreciate that very much.
Well, and thanks. Yeah, I had got double booked. I had a conference call that I had to bug out of early to get here on time. So.
Well, I appreciate you doing that. What's happening in your office these days?
Well, a lot. We have a lot of drug cases, of course, because our drug task force has been very effective at pursuing a lot of drug cases. With there's a lot going on. They keep us busy with bringing in new clients, new people to deal with every day, or every week at least, and so we've got a lot going on. I'll tell you, we've got the one of the cases that is coming up that we're going to have to deal with sooner or later is this Tim Chambers case, and I don't know if you remember that case, but that was the sad story of Deputy Liebenstein,
yeah,
who was killed at the county at the intersection of County Road 1 and I-35 and 20 years ago, 1996. And Chambers had stolen a car from Shakopee, ran down the freeway and aimed the stolen car at Deputy Liebenstein, and unfortunately Deputy Liebenstein was killed. And Chambers was convicted of first-degree murder and sentenced to life without release. And in a couple of years ago, the U.S. Supreme Court said that it's cruel and unusual punishment for juveniles to be sentenced to life without release. And Chambers appealed that decision to the Minnesota Supreme Court and said that should apply to him. The Minnesota Supreme Court said it does not. And a couple of weeks ago, the U.S. Supreme Court said that that original decision, Miller v. Alabama, is retroactive and applies to all juveniles sentenced to life without release. So we're going to have a sentencing hearing where a judge will have to decide whether Chambers gets life without release or life with some kind of release. And if he does, I think what it would mean is that he'd be subject to parole probably about 10 years from now at the earliest. And a parole board would make the decision after that, but he's going to have to come back to a Rice County court sometime in the next couple of months. So that's one of the things I've been working on. And
so what is your stand on this?
Well, we're evaluating those decisions very carefully. There are a couple of court cases we need to look at. There's that Miller v. Alabama decision from the U.S. Supreme Court. There is the Mahdi case Mahdi Ali out of Minneapolis. That was the Somali kid who was the shooter at a market in Minneapolis. And there the Supreme Court said the appropriate resolution was to have what they call the Miller hearing, where they get an opportunity to show that this is a person who can be redeemed and should someday be released. So we're going to have to figure out what that hearing looks like, and who's got the burden of proof. Do we have to prove that he needs to stay in prison forever, or do they have to prove that he shouldn't? And those are the questions that I don't know the answers to today, and at some point we're going to have to ask a judge to make those decisions.
We're going to touch on the Supreme Court nominee a little bit later on in the program, because I'd really be curious on your take on the appointment of a replacement.
I'm not accepting the nomination at this point.
Well, you've heard it first right here on KDH.
It's too long of a commute for me. I like this drive much better.
Yeah, well, I don't know if I'd want to be sitting on the Supreme Court either, but it is a lifetime thing once you get on there.
Right.
Why is that?
The idea, I think, from the founders' standpoint, was that the Supreme Court and now the federal court judges should be immune from political influence, that they shouldn't be making their decisions based on political short-term. They should be making their decisions based on what the appropriate view of the Constitution is. Now, federal judges can be removed the same way a president can be removed by impeachment, okay, by the House and Senate. And it has happened that federal district judges have been removed that way.
Belle Plaine, also Osage in Northwood, Iowa, are another KDHL Agri Booster. John Fossum, Rice County Attorney, is with us. We were touching on Chambers case, the case of Timothy Chambers, and the sad tragedy that happened 20 years ago. 20 years ago, back in 1996, when Deputy Liebenstein was killed, as Chambers had stolen a vehicle and came off a ramp and crushed the squad car, and of course the deputy couldn't get out of the way in time.
Right, and yeah, and unfortunately, Deputy Liebenstein was killed, and you know, it's a real tragedy for the community, a great loss to lose Deputy Liebenstein. And the question we'll have is there, you know, what can we do to establish that this is a case of where there should be life without release? I would point out that from what the research we've done into it is that, you know, really our parole system where we had life, and what we do is we make people eligible for parole after 30 years, but it doesn't mean that they get out, and it doesn't mean they get out right away. I don't know if you saw the other day, Sirhan came up for parole in
he
California.
He doesn't remember stuff or something, so he's...
Right. Charles Manson comes up for parole from time to time. So being eligible for parole and being released are not the same thing.
Right.
And also, if there is a release at some point, the person is on, in Minnesota, what we call supervised release. And if anything does happen, if they have problems, if they violate the rules, they could wind up back in prison for the rest of their life.
Well, refresh my memory, Chambers was like 17, wasn't he?
He was 17 at the time.
So, I mean, you're a year away from being an adult.
Right. Which is one of the issues, you know, and that's what I've been looking at and arguing, because when you read these cases, the U.S. Supreme Court cases, Miller v. Alabama, they're talking about a 14-year-old kid and a 15-year-old kid, and you know, a 14-year-old kid who really was in a convenience store, and his friend had the gun, and so he's serving life without release. To me, that's a little more sympathetic than a kid who aims a car at a deputy who's trying to slow him down and
he used it as a weapon.
Right. Exactly. And so it's but finding those distinctions and finding the difference and where the court is, because the Supreme Court really has made it clear that they don't like life without release for juveniles, and that it's going to be a very small class of juveniles who would be eligible for life without release. And they
I guess killing a police officer might throw you in that category.
And we were discussing off the air that in Minnesota at that time there were only 2 crimes that would get you life without release, and that was murder of a police officer and murder while committing rape, or if you'd committed prior murders, then you could get life without release. So it wasn't like we were using it for everything. And now all first-degree murder cases can get your life without release. So the law has changed significantly over those 20 years. And so whether that distinction makes any difference when we're dealing with this Supreme Court precedent is one of the issues we're trying to sift through. And I don't know the answers to it today, Gordy. And when we get an answer, I'll come back and tell you what it is. But
well, there must be some other. There are no other juvenile.
There are, I think, 7 or 8 cases in Minnesota serving life without release, and so we're all kind of dealing with this at the same time. And last year there was a bill before the legislature to make some changes, and that didn't go through. One of the things we might do is wait and see what the legislature does, and see how we can comply with what the legislature created before we get a resentencing, because again, we're not talking about his release anytime soon. We're talking about at most his eligibility for release in 10 years or more.
Yeah, because, well, it's been 20 years. He was 17, so
right.
He's now under 40.
Right. So he's probably about the age that John Liebenstein was when John was killed.
I guess I don't remember how old John was.
Well, he was a little bit older than me. He was a couple years older than me. So we're talking 20 years ago. He was probably about 40.
Okay. I guess that does sound about right.
Yeah.
He was a great guy. Always enjoyed seeing him over at the courthouse. big bear of a guy.
Right. Yeah, and I didn't know him that well. I sort of knew who he was. That was, again, 20 years ago, that was about the time that I was sort of moving down here. I was still living in St. Paul at that point and moving my practice to Northfield. So I run into him, but I knew his family. His mother was my 9th grade German teacher. His sister was a classmate of mine. So I have a lot of connections with that family as well. And so it's a loss that I think we all take kind of personally. The only question is, what do our legal obligations do with that, and where do we wind up?
Yeah, well, children grew up without a dad, wife lost a husband, mother lost a son, the whole community lost a good law enforcement officer. So what price should the individual who takes that life away pay? Guess that's the question.
That's the question, but do we have an answer to that? And we can't. Obviously, we can't restore him to, and we can't restore the community to what it would have been if John Liebenstein had been here for the last 20 years. There's no way to fix that. So the question is, what does our punishment system allow? What does our Constitution allow? And what arguments do we have? And obviously, at this point, we're still looking for life without release. The only question is, are we going to be able to convince a court that that's the appropriate resolution? And I don't know the answer to that one.
Right. Speaking of the Supreme Court, there's a bit of controversy here on whether the president should appoint a replacement after their death, the passing of Antonin Scalia, or whether they should wait till the next president. Senator Amy Klobuchar, I know, says, did I bring that with me? Yes, I did. Senator Klobuchar says, since 1975, it's taken on average 60 days from when the president announces a nominee to when he or she is confirmed. And she says that the current sitting president, should make a nomination.
Well, I tend to think that's what the Constitution compels, that the president shall nominate, and the Senate shall advise and consent. They use the 18th century spelling of advice, and we think they mean advise, but we don't really know.
Yeah.
So I think there should be they should go through the process. I think that is the obligation of the Senate to have an up or down vote on the president's nominee, and to send it through the system. It doesn't mean they have to confirm whoever the president nominates, but it does mean that they should probably go through that process.
Right, and it's an election year, obviously, so you can see why some are thinking maybe the next president should make that choice.
Well, and from what I've been looking at, President Eisenhower nominated candidates who the Senate didn't hear, and he made recess appointments. So when the Senate went into recess, he appointed, I think, William Brennan, who served for a very long time after that, and a couple of other, at least one other recess appointment to the Supreme Court. So that's not unprecedented either. And they were later confirmed by the Senate after that election.
They were already there.
Yeah, after they were already there. And so that, I think the precedent is, and the practice and the Constitution basically require that the president should make his nomination, and the Senate should probably hear it and make their decisions however they make their decisions.
So it's much ado about nothing is what I get to gather from your stance on this.
Well, that would be my theory, that everyone should do their jobs.
Makes perfect sense to me, John. Makes perfect sense. John Fossum's with us. He's Rice County's attorney. I don't suppose you have plans yet for the fair, right?
Not yet.
It's a few months off.
Right. We'll have to look at what we're going to do for the fair.
Did see this last week, the Minnesota Court of Appeals. Do you look at all these rulings when they come down? And there's so many of them, it's hard to keep up with them.
There's a lot of them. Normally I read the ones that involve our office, and I read the ones that are precedent, and I think the one you're looking at was a published opinion, so I went back and looked at it.
Well, I think it's very interesting. That's why I brought it up. I mean, a judge gets pulled over for driving drunk.
She's not a judge,
well,
actually.
I'm sorry. She was an aspiring judge.
Right. She ran for the Minnesota Supreme Court.
Yes.
And did not win. But her argument was kind of interesting. It's one we see a lot, frankly. because the statutes and some statutes and the rules say that someone is to be brought immediately before a judge, and the question is, what does that mean? Does that mean at 3 o'clock in the morning you have to go find a judge? And the reality is that's not what that means. It means that in the ordinary course of business, and we have other rules that apply to that. So really what it means is, if we're going to hold somebody in custody, we have to bring them before a judge within 36 or 48 hours, depending on how those rules are implemented. So if we pick somebody up on a Friday night, and we want to hold them over till Monday, there has to be a judge that rules on that, normally on Saturday, to say, yes, there is probable cause to hold this person for court, and then they'll appear for court for a bail hearing on Monday.
But wasn't her argument that she refused the test?
Yeah, most of the opinion is about this question of whether or not she had to be brought before a judge before she took the test.
Right.
And so most of the opinion is about, no, she doesn't have to be brought before a judge before she takes the test. She has to be brought before a judge if she's going to be held in custody. And so she was saying she didn't have to take the test because she didn't get to see a judge before she took the test.
Yep.
Which obviously we don't have judges sitting at the police station, at the jail every night, waiting to see who gets brought in and say, okay, come talk to the judge. We have to bring them before a judge within that ordinary course of business. And we've had people argue this on speeding tickets too, because there's a rule that says that someone shall be brought before the court immediately. Well, what does immediately mean? It means in the ordinary course of business. It means as soon as possible. So if we're going to hold them in custody, they need to be in front of a judge within 36 or 48 hours, depending on which one of those rules applies. And it doesn't mean right now. It doesn't mean instantly. It means, in the ordinary course of business.
But I have heard attorneys say, when you get pulled over for drunk driving, you should refuse the test until you talk to an attorney.
I would not say that.
That is not good legal advice, right?
I would not say that, but I'm not in a position to advise people who want to, obviously that's not where we are. We're looking at, so I don't know who advises people to do that, but I certainly wouldn't advise people to do that, but I'm not in a position to advise people who are being stopped for drinking and driving, because I'm representing the I'm representing the police.
Yeah, you can't.
Sheriff Dunn and I would have a different opinion on that.
Of course you would. Of course you would. But I was just trying to get at the whole legal proceeding involved here.
Right.
And the best advice would be to submit to the test. And can you say that much or not?
I can't say that much either, because I don't want to. I can't give. I can only represent two clients anymore. I can represent the state of Minnesota and Rice County. And anybody else has to go hire somebody else to talk to.
You can't give legal advice.
That's right.
To anybody.
Right.
Except the county board.
Except for the county, and I represent the state when we're prosecuting people. So those are my only two clients anymore.
So that's unfortunate. We'll have to see if I can get some defense attorney on here to talk about it. But then
I bet you could.
That might be someone who is an advocate of refusing the test.
And they could explain their reason for doing that and why they think, why they would advise somebody to commit a crime.
Again, John Fossum is with us. He is Rice County's attorney. We appreciate his coming on every month to discuss various items of interest. I really was interested in finding out your take on the appointment, and it seems cut and dry to me too. Hey, president's duty is to appoint someone, and it's
President has another, I think, 11 months in office, and that Justice Kennedy was confirmed in an election year. I think Justice Scalia was confirmed in 1987, 1986 or 1987. I mean, whose election year are we talking about? And so I think the long-standing history is that the president appoints, and the Senate performs their function of advice and consent.
But getting back to this lifetime appointment of a Supreme Court justice, our founders didn't think people would be living into their 90s back in the day.
Well, it's
extremely rare.
Justice Holmes was 110 or something when he died, and that was turn of the century, turn of the last century. Like I think he was appointed in the at the end of the 19th century and lived well into the 20th century. So it's not unprecedented that
No.
people would live a long time. And I think the point is to make these positions less political, so that the judges will do things that follow the law rather than things that will make them more popular at the ballot box. And there's always been a lot of concern about, if we do have elected judges, what are they running for, and how do we have these elections, and how do we make the appropriate decision? I know when I was running for office, a lot of people said they didn't know what a county attorney does or how to make a decision, and they say, a lot of them say the same thing about the judges. They don't know anything about the judges when they're voting for them, and
well, that's probably true.
And they don't know how to make a decision if there is a contested election. Now, we have judges who run for office in Minnesota, but we don't have a lot of contested elections, at least in this area. Our judicial district is 11 counties, and so you've got Rice, Winona, and Olmsted, that's the majority of the population, and then you have 8 much smaller counties who we rarely see people run for office against the district court judges in this area. And the real question is, how do you decide? How would people get enough information and make a decision? Our appellate court judges occasionally get opponents, and sometimes our Supreme Court judges, just like the case we were talking about earlier, where that woman was running for.
She got defeated by David Littlehog.
Right. So she ran against a sitting Supreme Court judge, and how did people make the decision on which one of those people they were going to vote for? A lot of times it's somebody makes an unpopular decision, and that's the basis for someone else to run against them. And I think it's complex. I don't think there's any one good answer to that. Obviously, it's something we've dealt with and talked about for a long time, but I don't know whether we should have elected judges, or whether we should, how do we isolate judges from politics?
Well, which is more political, the governor appointing a judge, or the president appointing a judge, or people electing a judge? That's
right.
The question. Which is more political?
And which is more political, and how do we, maintain good conduct without elections or some sort of review? Do we have impeachment of judges? I mean, as I said, that has happened.
You don't see that very often here, but yeah, it's happened before in the past.
And I think there was actually a judge in Florida, federal judge in Florida, who lost his seat. He was impeached by the Senate, and then he ran for the U.S. House, and now he sits in the U.S. House. So, I don't know the answer to those questions, Gordy, but I think they're good questions for people to ask and think about and argue.
Yeah, it's been going on for a long time. Somehow I don't think it's going to change anytime soon.
No.
John Fossum is Rice County's attorney. Anything coming up that you want to let listeners know about?
We're just proceeding through our cases, and when something happens, we'll let you know. We've got a couple of big things coming up, but I always try not to talk about them before they happen, because I don't want to be accused by the defense of prejudicing the jury or trying to convince people to vote a certain way, and so we're always trying to not talk about our pending stuff.
You mentioned earlier, I think it was drugs.
Yeah.
You have a lot of cases involved there. You have a drug court now. How's that work?
We have a drug court, and we've got, I think we're pretty close to having our first graduate at the drug court. We've got someone who's doing really quite well, and hopefully we'll have a graduation soon, and maybe another one shortly after that. And that will be the real measure of the success of the drug court. If people complete this program and can stay clean and turn their lives around and be productive citizens with jobs and not people who are sitting in prison or consuming public resources, I think that'll be great.
That coincides with what the there's a legislative panel recently that said we should lower the sentences for some drug crimes.
Yeah, and that's the Minnesota Sentencing Guidelines Commission changed, made a proposal to change the sentencing guidelines, and if the legislature doesn't act on it, those guidelines will go in effect. And the real effect of it is that anyone convicted of their first drug crime, unless it's a real first degree, serious, high amount of drugs, they're not going to face a prison sentence. If they've got multiple drug offenses or are subject to one of the mandatory minimum sentences or have multiple other felonies, then that's someone who would be maybe going to prison. I think we're going to have to work out how this drug court is going to work and deal with these changes in the sentencing guidelines if that's what comes up, because we ask a lot of people in drug court. We ask them to do, they give up a lot of freedom, and it's not just probation, it's serious kind of oversight, and they have to come in and commit to the program and work through it. And so one of the ways, what incentive do they need to comply with all those requirements? And if there's no prison sentence in the background, some people may not, won't want to participate.
And I do remember one of our prison wardens, Minnesota Correctional Facility here in Faribault, on this very program one time telling me that about, I think he said, and this is a long time ago, I think it was like 80% of the people in the prison were under the influence of some chemical, whether it be alcohol, drugs, when they committed their crime.
And that's a very high percentage of the stuff that we deal with. There are people with substance abuse problems. Not all of them are going to qualify for our drug court, but the ones that do, hopefully we'll be able to help them out and save the public some money.
All right. Hey, thanks, John. I appreciate it. Look forward to next month.
All right, thank you.
John Fossum, Rice County's attorney, our guest. Rice County Habitat for Humanity comes by on Monday. They have an ice golf tournament next Saturday, if we have any ice next weekend. You're in tune to KDHL AM Faribault.